Thank you everyone for coming. I've divided the talk into various categories, and the first category is cases. There are 3 cases that have been handed down that deal with compensation from the Torrens Assurance Fund. I think 2 cases are from New South Wales, but 1 is from Queensland. This case is quite interesting. The developer said that the area of the lot had been misstated, and they claimed for compensation on the basis that they had been deprived, obviously, of land or of any estate or interest in the land as a, no, sorry, withdraw that. The area of the land was misstated, and they, as I said, they sought compensation. The Registrar General said that they weren't liable to pay any compensation because on 2 bases. One was that the loss or damage was a consequence of an act or omission by that person, and that's actually what the court found. They said that the developer should have measured the land to make sure that the measurements were accurate. So that objection was upheld, and the second basis upon which the Registrar General disputed their entitlement to compensation was that 129(2) subsection E, where the loss or damage arises because of an error or miscalculation in the measurement of land. And so, I mean, for obvious reasons, the way I've told you the facts, it's clear that it falls within this exclusion, because the whole loss or damage was because of an error or miscalculation in the measurement of land. So I don't quite understand why this case went all the way to the Court of Appeal, but because it went, I thought I'd share that with you. The second case is the case of G Holdings and Registrar General of New South Wales. In this case, yet again, it was a developer who was upset that an easement didn't show up on the title of the property. And they said that they had suffered loss or damage, but they weren't seeking compensation on the basis that they had paid too much for the land. That wasn't what it was. They were just upset about the development potential of the land. And they were unsuccessful, yet again, because the court found that they were not precluded from carrying out the development. And as you can see in the third box, the council also had the power to suspend the easement under the relevant LEP, or to permit a development without any car parking on the ground level. And as a result of that, as a result of the fact that the development wasn't precluded and it could have continued, the court said that the market value of the land, both burdened with or without the easement, would be the same, so there was no damage. The next case is, I think, quite interesting. It's run under the equivalent section in Queensland, and in this particular case, the son had defrauded his mother, basically, and had, as we are not surprised, forged the mortgage documents. And when the mortgagee went to sell the property, before it could be registered, a caveat was placed on title. And so the purchaser negotiated and agreed to withdraw from the sale. But as a result, the purchaser brought a claim for compensation for $2.7 million under the Torrens Assurance Fund. And one of the arguments of the Registrar General was that they didn't have to pay compensation because the relevant section only protected equitable interests. Because when you have a look at the section, you'll see that it says that it's protecting loss of an interest, but it doesn't say whether it's legal or equitable. And the argument of the Registrar General was that it only protected equitable interest, but the court didn't accept that and said that the section protected not only legal but equitable interest as well. And as a result, the purchaser had lost their interest in the land and was awarded compensation in the amount of $2.7 million. So I thought that was interesting because I've always wondered when I could myself claim on the Torrens Assurance Fund. And then the next case I only highlight because half of you are family lawyers, but it's another case in the New South Wales Court of Appeal. And in that case, the father had helped the daughter buy a property. It was initially purchased for $300,000. The father had loaned the daughter $75,000 and then actually entered into a loan agreement, I think, yes. And on top of that, had during the course of the time that the daughter owned the property, had paid had paid funds towards the mortgage and other expenses for the property. But when John's relationship broke down with his partner, it was agreed that the property would be sold and the proceeds held on trust while it was sorted out through the courts who actually owned the property. John said that he owned the whole of the property and that the 25% of the property, which is the share of $75,000 out of $300,000, was held on a resulting trust for him, and the rest of the property, the 75%, was his because he said that he had been paying for the mortgage and other expenses. But the court looked at the documents, tracked all through the documents through the case and decided no, in effect, it was a loan. The $75,000 was a loan, and so that got rid of the $75,000, the 25% argument. And in relation to the 75% that he said that he owned, the court said, well, there's a presumption of advancement. You've given this money to your daughter. The presumption is, as you all know, that that was a gift. And the court held that John had not been able to rebut the presumption that the monies had been gifted to his daughter. So at the end of the day, I guess all he got out of it was the repayment of his 25% of the property, which ultimately sold for just under $500,000. Now the next category of case I want to talk about is specific performance. I found this case particularly interesting because this case ordered specific performance against the vendor. No, not against the vendor, in favor of the vendor. So the purchaser had sought to obviously not go through with the sale, and the purchaser, the vendor sought specific performance. And you may all know that specific performance is ordered in property cases because essentially it's considered that damages is not an adequate remedy when you're going to buy a property. But in this case, the court said that that also applies in relation to vendors because at the end of the day, this is the principle that every seller has the right to divest themselves legally of the estate in exchange for the agreed sum. And damages is not an adequate remedy because if they went to court and sued for it, they would get damages, they would still be stuck with the property. So I thought that was interesting. But in this case, it wasn't the purchaser who had the funds to pay the money, it was the guarantor. And so the case was actually brought against the guarantor, and another issue in that case was whether or not the guarantor had a principal obligation to complete the sale. And as a matter of construction of the guarantee, the court found that the guarantor did have the principal obligation. So in this case, the guarantor was ordered to pay the vendor the purchase price, and the sale presumably would go through. Now, this next case is a High Court case. It's very interesting. It was a sale of a pub during COVID. It was sold, I think exchange was before COVID, and then it was a term of the contract that the business had to be carried on in the usual and ordinary way as regards its nature, scope, and manner. And obviously during COVID there was lockdown and the business could not continue to trade as normal. And when it came to the completion of the contract, the purchaser complained that the vendor had been in breach of this term of the contract. And at issue is whether or not the vendor was only obliged to carry on the business lawfully. And in this particular case, the High Court said that really, as a matter of construction of the contract, and in particular of this particular clause, and in particular where it says you have to carry on business in the usual and ordinary way as regards its nature, scope, and manner. Inherent in that is that the vendor only has to carry on their business lawfully. So there's no obligation for the vendor to be carrying on business when at law they weren't allowed to. So at the end of the day, the purchaser was in breach of the sale of business contract by failing to complete. And just the next case is, I'll just mention very quickly, it's the jurisdiction of the NCAT. And what happened was that NCAT had forgotten to consider whether or not it had jurisdiction to opine upon whether a certain agreement was, a building management agreement that falls within the Strata Schemes Development Act. And it went all the way to the Court of Appeal, and at that time there were concurrent proceedings running in the Supreme Court on this issue as well. But the NCAT Appeal Tribunal had forgotten to consider whether or not it had the jurisdiction to consider that issue, and it went on. And the Court of Appeal said that it sent the matter back to NCAT and said that the slip rule could be used to order the NCAT Tribunal to consider the very issue of jurisdiction and then to amend its results to fill in the blanks. Okay, the next two cases I wanted to talk about was options and whether conditions precedents can be waived. David finds this particular case curious, but hopefully I will be able to explain to you why in this particular case the court found that the beneficiary or the lessor could not waive these particular obligations. So what happened here was Willis was the lessee. Willis rented a particular space, and then it had an option to renew that space and also to obtain an additional space. So at the relevant time, it exercised both options, and it for Part A and Part B. There were 5 conditions precedent to the exercise of the option, and they complied with the first 3 conditions precedent, but they didn't provide the bank guarantee. They only provided a bank guarantee that covered Part A, but they didn't provide a bank guarantee that covered Part B. And 6 or so months after they had exercised this option, it sought to retract the exercise of its option for Part B. And the landlord said, no, you can't, you cannot, it's an irrevocable offer, and you cannot withdraw your option. So it went, as you can see, all the way to the Court of Appeal, and the Court of Appeal said, there's a standing dispute as to whether or not the nature of an options agreement is whether or not it's an irrevocable offer or whether it's a conditional contract. But the Court of Appeal said it really doesn't matter. We just need to construe the option agreement, and at the end of the day, while it is true that a lessor can waive the benefit of it can waive benefits that are meant for it. That's a very poor way of saying that, but it couldn't waive the benefit, it couldn't waive 2 of the preconditions because it said that the landlord was not entitled to compel the lessee to actually exercise the option. So and because of that, it had no right to compel the lessee to satisfy any of the preconditions, and because of that, it couldn't then waive the need for the lessee to provide it with the bank guarantee in the right amount. I hope I've explained that properly. Because David thinks that it's curious that the landlord couldn't turn around and say, don't worry about the fact that you haven't given me the bank guarantee. But at the end of the day, I do think the Court of Appeal is correct because it is only the lessee who has the right to decide whether or not it's going to exercise the option, and it's then up to it to satisfy all the conditions precedent before it can exercise that option. The next case is I'll just mention it quickly, V. Quattro and Townsville Pharmacy. And once again, in this case, it was again in relation to the provision of a $10 million fee. And as a matter of construction, the option agreement was exercised, and then under the contract, it required I think it was the lessee, to pay the lessor $10 million within 2 business days of the entry into the agreement. So the way the option agreement worked was that you exercise the option, an agreement comes into force, and then within 2 business days you have to pay the $10 million. So there was a delay, obviously, in the payment of the $10 million, and the argument was that the option hadn't been exercised properly because the conditions precedent hadn't been satisfied. That is the payment of the $10 million within 2 business days of the contract. But the Queensland Court of Appeal construed the option agreement and decided that the promise to pay the $10 million within 2 days of the entry into the agreement was not a condition precedent. That at the time of the exercise of the option, the agreement had come into force, and the obligation to pay the $10 million was merely a promise and not a condition precedent. So the lessee was bound by the agreement and the exercise of the option. I'll just mention this next. There's only one case, adverse possession of Crown land, and it's Carver and the State of New South Wales. It's a Court of Appeal decision. And in this case, Mr. Carver had been living on this property for many, many, many years. It was Crown land, and initially he had been renting from a lady, I can't remember what her name was, and then he stopped paying rent to her, I think from about 1996, and he continued to live there, and he had on many occasions tried to enter into an agreement or a lease with the Crown to lease him this land, but the Crown had refused, and at the end of the day, he was obviously living there for many years, and he said that he had actually, as a result of staying there for such a long time, gained himself some squatters' rights, adverse possession. But the court said, the main difficulty was that it was Crown land, and if you step yourself through the Crown Land Management Act, you can't have adverse possession of Crown land. So that basically got rid of his case. But secondly, the case also talked about the difference between permissive occupancy versus squatters' rights. And at the end of the day, what had happened here was that he had enjoyed the benefits of a permissive occupancy rather than gaining himself any adverse possession rights. How am I going for time? 10 minutes. Okay. The next case is Section 66L of the Conveyancing Act and substantial damage to land. I'm not sure if you know, but if you enter into a contract for sale and your property is substantially damaged between exchange and completion, and in the past, prior to this, the cases that I had looked at only dealt with when the property was completely damaged by fire, that you can then rely on Section 66L to rescind the contract. But in this particular case, Retirement Village, Bargo, and Anwar, the land was only contaminated with asbestos after exchange, and the owner had tried to get the asbestos cleaned up, but it was unsuccessful. And the vendor served a notice to complete, and it was clear at the time that the notice to complete was served that it would be impossible for the land to be remediated by the time of completion. And so the purchaser then purported to terminate the contract at the time that the notice to complete was served, and the court said that the purported termination was valid because it was clear at the time that the notice to complete was served that it would be impossible for the land to be remediated by the date of completion. So this case is interesting, and you should also be aware of the next section in the Conveyancing Act, Section 66M, where it deals with the situation where the land hasn't completely damaged, but when you might be able to claim compensation, even though it does compel you to complete the contract when the land is damaged. But that's a talk for another time. Okay, so here there's a few cases here I've collected which deals with the validity of termination of the contract for sale. And it comes down to whether or not here the seller has complied with the terms of the sale of land contract. So in this particular sale of contract, it allowed the vendor to terminate the sale agreement if the responsible authority imposed a requirement that, in the opinion of the vendor, in its absolute discretion, was too onerous for the vendor to perform. And so if you're looking at it in a literal reading of it, it does appear that the vendor can just decide whether or not, in its absolute discretion, it's going to, the condition has been too onerous and seek to rescind the contract. But the court said that the power is not absolute at all, and it cannot be exercised arbitrarily, capriciously, or unreasonably. And in the circumstances of this particular case, it was held that the vendor wasn't allowed to rely upon special condition 10.7. But the takeaway from this is that regardless of the apparent literal reading of the clause, you cannot exercise it arbitrarily, capriciously, or unreasonably. The next case deals with whether or not the property is really owned as a joint tenant or tenants in common in equity. In this particular case, the title noted that the ownership was between a man and a woman, I think they were in a relationship, was noted as joint tenants. But at the time that the property was purchased, the male, I think Mr. Whitty, is it Whitty? The male part of the relationship had entered into a loan agreement with his siblings, stating that he was borrowing, I guess, the money from his siblings to purchase the land. And at the end of the day, in his will, he had also provided his partner, with the right of first refusal to buy the property upon his death. And so when he did die, the case was brought by his estate against the female. And the argument was that in equity, despite the fact of what it was said on the certificate of title, the relationship between, the nature of the interest between Whitty and Talia was actually tenants in common. And the court looked at the documents, the contemporaneous documents, and decided that because what was critical for them was that a loan agreement had been entered into with the siblings, and also this right of first refusal upon the death of the male meant that, in effect, the parties had really intended for the interest to be held as tenants in common. And I'm just going to mention this case. It was an attempt to terminate a strata scheme using Section 136 of the Strata Schemes Development Act. That was unsuccessful for various reasons, but it's an important case because, it was an attempt to do this, but it was unsuccessful. And it's a matter within the complete discretion, I think, of the court as to what issues they will look at in considering whether or not to exercise the power. It was to deal with the Mascot Towers, which was, I hope you all know, that is basically condemned, it can't be lived in. And they had actually borrowed, I think, $40 million to try and rectify the defects, but it didn't work. And the property was in limbo, and the owner strata plan wanted to terminate it. But the judge wasn't satisfied that the discretion should be exercised to terminate the scheme, and the relevant considerations are noted there. I think the property is now being sold. But at the end of the day, I think the court said that the owner's corporation was not insolvent, and that they weren't satisfied that all of the lot owners actually understood what was going on. And she also, Justice Peden also had to consider the interests of the registered mortgagees as well as the unsecured creditors. So at the end of the day, she wasn't satisfied that her powers should be exercised to terminate the strata scheme. And I think this is the very last case. What was being construed was that the expert determination, whether the expert determination exhibited a manifest error. And the Court of Appeal looked at cases in the Commercial Arbitration Act context and looked at where the phrase manifest error had been considered, and said that at the end of the day, the error must be apparent on the face of the expert's determination and accompanying reasons. So it must be apparent or obvious from a reading of the determination and the reasons. And it's not good enough if the error is only revealed because there's an arguable error of law or during a litigious process that it becomes apparent that there could be an arguable error. So arguable is not enough. It has to be really obvious from a mere reading of the determination and the reasons that a mistake has been made. So that's it for me. Thank you very much. Over to you.
Good morning, everyone. Does that work? Yeah. Firstly, can I thank everyone for coming? It's genuinely flattering there are so many people here and have such an interest in the subject, so thank you very much. I know we all have to get our points up, so hopefully we'll get that done too. I don't come to Newcastle all that often, not enough, but that view is fantastic. And for those that live here, it must be a real joy seeing that sort of view on a regular basis. The third preliminary point is an apology in advance. Where I appear, you don't get to use audio-visual aids much. The judges in the Court of Appeal don't really like them. And so it's all paper, and so without estimating enough attendees, there should be a few papers on your desk, on your tables to share, which are effectively the speaking notes, which I'd be taking you through as if you were the Court of Appeal. So I'm sorry it's not ideal, but we'll just see what we can do. For better or worse, the topic of what I'd like to speak about is more focused, and that's on section 66 ZS, capital Z, capital S of the Conveyancing Act. Now, I'm sure some, but perhaps not all of you know, that's the section of the Conveyancing Act which regulates, restricts the ability of a developer vendor in off-the-plan contracts for sale of land from rescinding the contracts without the leave of the Supreme Court or the consent agreement of the purchaser. Now, so that's 66 ZS. For a while, it was called, the same section was called 66 ZL. Sort of the Tax Act hits the Conveyancing Act, but it's the same section. It's been around since 2015, and I'll go through some of the cases. The reason I chose it, there's a particular issue that's emerged recently in relation to the operation of the sections, which I'll come to, and also because of the state government's determination, quite proper most people believe, to push through rezoning with the intention of increasing housing density in New South Wales. There will be many, many more off-the-plan sales by developers who wish to take advantage of rezonings that have occurred. Even in Newcastle, as I'm sure you obviously all know, what's going on down at the waterfront, that would all have been off-the-plan sales. So it's a significant area of commercial activity coming up. There are already about, according to some of the publications from the government that come out, about 200,000 off-the-plan sales a year. It's gone up and down a bit with COVID, but it's anticipated there'll be more. So that's hopefully the topic in general will be of interest to the people here today in relation to their practices and, if nothing else, their own knowledge. Can I just initially say, off-the-plan sales, the expression does relate to, strictly speaking, residential and non-residential land, and also does include land-only sales, or off-the-plan land-only sales, or land and building sales, or most commonly known, or most commonly spoken about by the public anyway, in the strata context. The point being is there are a number of contexts in relation to which off-the-plan sales can occur. For those practitioners and those with experience in this method of purchasing property, that you'd be familiar there are many advantages, or advantages and disadvantages of off-the-plan purchases. For the developer vendor, the one making the money, the main advantage is that they can get finance. So it's usually a precondition of a grant of finance by a bank or other lender that a certain degree of pre-sales are achieved by the developer before the financing becomes available. Sometimes 60, 70 or 80% of pre-sales. So that's why they need it. And apocryphally, and I can tell you from personal experience, in the past anyway, some of the off-the-plan sales achieved by some developer vendors are a bit dodgy. They're off-the-plan sales to their friends or family and things like that, and then I'm not sure they really ever intend to invoke them as legitimate contracts that get the funding over the line, but that's neither here nor there for present purposes. That's the main thing for the vendors, developers. For the purchasers, the mums and dads, sometimes other smaller scale developers, the mix of advantages and disadvantages is a bit more nuanced. Obviously, the main point is that usually they get a reduced deposit, sometimes down to 5% rather than 10%, and often the developers take bank guarantees instead of putting up hard cash for the deposit. There's the ability for the off-the-plan purchaser to save money for the ultimate purchase price, obtain their funding. There's also the ability of the purchaser to take advantage of the possibility of on-selling the right before it comes to time to purchase. That is, they can on-sell the ability or the right under the contract to another party and make presumably a profit from that sale before it comes time to actually complete. I think it's in the share context that's called stagging, but I don't think that's come across to real property law. There's some talk about these people getting a reduced price, the purchasers getting a reduced price from what the ultimate at the time they enter into the contract to the time they come to purchase, usually in about 18 months' time, or about sometimes longer. That's more, again, apocryphal. I've spoken to experts about this for the purpose of these sort of cases, and the experts sort of say, well, look, there is some perception in the market that with strata at least, purchasers of completed strata properties pay more than people earlier in time who just look at a plan and see the upside and the potentiality. Because it goes without saying, many people want to avoid the uncertainty of that process, the delay, the potential that the developer may become insolvent and the whole thing falls over. And they would rather see the views, the aspect, the layout of the whole dwellings, particularly strata and the like. So There is some benefit that way, but the major downside, as I say, for purchasers, and we as legal practitioners advising that purchasers need to make sure they're aware of the main problem is delay and these sunset clauses, which I'm about to talk about, but obviously also commercial aspects, that there might be a failure by the liquidation by the builder or the developer, which happens, and the like. They have to pay stamp duty in advance. Anyway, so that's a bit of a background. Some of that's not all legal, and I'm sure most people here in this room, by reason of their practice and personal experience, know most of what I've already said. And then turn to the expression, what is off the plan sale, in a bit more detail. It has potentially many meanings, but the one which is most conveniently used, and I'll be using largely, is one which the legislature has applied to residential properties, and which is the subject of these restraints on rescission. So it can mean more, but what the legislature has defined it for the purposes of this talk is a contract for sale of a residential lot that has not been created at the time of the contract. It's quite simple. It's quite pretty, actually. So if you've entered a contract for sale of land, we've seen them all, and the land that is being sold is not yet created, that's an off-the-plan sale. Of course, the lay people would say, well, how can that be? You're selling land, but that's not the point, as we as lawyers know. What you're buying is not land, dirt. You're buying, in the glory of the Torrens system, you're buying a lot, and a lot is a product of a subdivision, usually of land, or strata lot, so the contracts which provide for the completion in respect of a property or a lot not yet created is an off-the-plan sale if it's for residential land. So that's a very neat definition. However, as I say, it has to be residential. Now, for those experienced conveyancers in the room, they know that the definition of residential lot is not entirely straightforward. But the first point to observe is that it brings with it, if it is a residential lot, an avalanche of additional obligations by a vendor and entitlements by a purchaser, cooling off and disclosure and matters such as that, as if you were buying any residential properties, off the plan or otherwise. So things like in section 66Q, properties, there's a definition which I won't bore you too much with, but it's in the material, about land on which there are situated, or could be situated, not more than 2 places of residence, vacant land upon which it is not unlawful to create a place of residence, and strata. And then also, however, it's not to be included land that's only for non-residential purposes, that's industrial presumably and agricultural, and land, importantly, that's more than 2.5 hectares in size. So any land that you're selling, a bit like the Residential Leases Act really, any land you're selling for more than 2.5, notwithstanding it might have a house or residence on it, is not a residential lot. But that's, as I say, brings with it the normal cavalcade of rights and obligations, as if you're buying or selling your own personal home, residential home. But so it backs onto that. So then turning relevantly to the idea of where we've got a lot, the issue is, well, when you've got an off-the-plan sale, was the lot's not created, and then the issue, particularly in relation to off-the-plan sales, is if there's a sunset clause, and that's the next trigger issue. A sunset clause, a sunset date, as I'm sure you all understand and know, is usually the contract provides that that something has to happen. Usually, we'll talk about that, it's called a sunset event in a minute. Something has to happen, usually it's the creation of the lot or the registration of the strata plan or something like that. And if that does not take place within 18 months is the usual period, can be 2 years, can be longer, then the vendor developer has the right or entitlement to rescind the contract. So the key definitions are sunset clause. That's a clause that gives the ability to rescind the contract if the sunset date event does not occur within the sunset period. So that's fairly straightforward. Has to be a period, has to be an event defined as a sunset event, and then if that doesn't occur within the relevant period, then you're in the game here, as it were, for this issue in respect of residential property. Now, sunset event. Now, this is where this issue has some topicality, and the particular reason I chose it for discussion. And this all appears, the definition of sunset event appears in section 66 ZL, but it means the creation of the subject lot. So we're talking about lots yet to be created. The creation of the subject lot, for the pure real property lawyers here, they know that's when the Registrar General creates the lot and you get your new folio identifier. The issue of an occupation certificate in relation to the subject lot, for those who may not be so familiar, that's what happens to effectively allow a certain stage of to signify that a certain stage of development, physical development, has occurred. So that's the second sunset event, and a third one is any event prescribed by regulations, and there is no other event prescribed by regulations currently. The regulations being the Conveyancing Sale of Land Regulation 2022. So sunset event is the creation of the lot, the subject lot, or the issue of an occupation certificate. And I've been doing this for years, and I didn't realise there's this massive hole in this, which we'll come to. I'll keep you in suspense. And this is what I brought to your attention today for. This is mainly the hole in the definition of sunset date, a sunset event. So can I just take a step back before diving back into that, just to touch on non-residential land. As I said, these provisions deal with residential land and a lot of property, obviously, and with which I'm sure you deal, as well as the non-residential land within those definitions, and off-the-plan sales in respect of non-residential property or land is largely unregulated in New South Wales. There is a standard clause, which I'm sure those regular practitioners in this area know well, in the Law Society form about unregistered plans, and that's clause 28.1, which is effectively a clause which says if there is an obligation in respect of a unregistered plan, then the vendor has to use reasonable endeavours to achieve the registration within the time provided. It's just a reasonable endeavours clause, which is the sort of thing you'd all understand from normal contract law, but nevertheless an express clause. And so that is what a vendor of off-the-plan non-residential land still has to overcome. They still have to, if they want to rescind on the basis of the failure to comply with the sunset date, then they've still got to satisfy, the onus being on them, that they have used their reasonable endeavours in accordance with Standard Clause 28.1. And when I was above, professionally that is, that used to be the clause that was the for all these matters. So that used to be how stratas and non-stratas, that was the operative clause, and it had the fights about whether or not the vendor, developer off the plan or strata or residential or non-residential had complied with that obligation. So, and so cases in respect of non-residential land still really fall for that fight, that consideration, that issue, but now we have for residential land a different regime. Now, the big change procedurally for those that are interested or care, it's a real game changer in the sense this legislation has been, because what was happening it still happens in non-residential land, and what was happening in the residential context was the developers would just say, I've rescinded, sue me. And you know, mums and dads just didn't. You know, they didn't want to take on a developer in respect of these lots. So this is why the legislation in 2015 was introduced to require for a developer, vendor for off the plan sales of residential land not to be able to just say rescind, sue me. It was to say you have to go to court to get leave to rescind. So yeah, so that was the biggest change, and given a reference to a decision of Rivat and in 2007, which was the old law in respect of even residential land, and it was about clause 28.1, and in that case there'd been a huge blowout of the cost of the construction, and the judge said, oh well, you used your best endeavours, this was not foreseeable at the time, therefore you're not in breach of the obligation to use reasonable endeavours. The reasonable endeavours obligation doesn't include you having to spend hundreds of thousands of dollars of unexpected money, and therefore the very brave purchaser who had to bring the proceedings lost. And that's still the position with non-residential land, but then we turn now to residential land. In 2015, the government, they called it emergency legislation, I'm not really sure why. It was just a fundamental change of policy, and introduced this regime, which we're going to talk a little bit more about. And it was said, and I think it's right, it was to change the allocation of risk resulting from delay. So that was what it was meant to do. It was meant to create a reversal or change in the allocation of risk, which is what contract law is all about, obviously, and create overview by the court in respect of the conduct of the particular developer. The regime was, the off-the-plan regime was extended. It became more complicated or complex or nuanced, if you like, in 2019, and that's the current legislation. And that's why we had this rather odd change of the same operative provision, which was section 66 ZL, which is to now the operative provision, which is section 66 ZS, but it's the same section. I don't know why they did that, but they did. Anyway, so the relevant provision we have is now in place. Now, for those three a table, you have the benefit of the bits of paper. The main issue is there's an obligation. This is 66 ZS. Obligation for the developer to have issued a notice saying you want to rescind. The courts have ultimately said, well, that's not an essential item, but nevertheless it's still there. And then an obligation that the developer is not able to rescind unless they obtain the consent of the court, or alternatively the agreement of the relevant other party, relevant purchaser. Now, can I say again, apocryphally, and I wouldn't have had any knowledge or notice of this happening. Some vendors just say, "I don't care. I'm just going to rescind and see what happens." So you know, they just do it, and some people make a fuss, as they should, and the off-the-plan purchase just takes a very substantial commercial land legal, obviously, with an awful conduct risk, but some of them do it anyway. So if you're advising your clients, you just need to be mindful that sometimes it's not unknown for developers just say, "I don't care, I'm just doing it." Because when we come to some of these cases, you'll see how hard it is now for off-the-plan developers to get leave of the court. In any event, so the overriding criteria for the grant of leave by the court to rescind is only if the vendor satisfies the court that the making of the order is just and equitable in the circumstances. As we all know, that's a very common expression in the law. And they say in determining whether or not it's just and equitable, the court is to take account of the terms of the contract, funnily enough, whether the vendor has acted unreasonably, that's the developer, unreasonably or in bad faith. The reason the sunset event did not occur by the sunset date, the likely date on which the sunset event will occur, whether the subject lot has increased in value, the effect of rescission on each purchaser, any other matter the court may think fit, sort of thing, anything prescribed by regulation that is not. One of the many stingers is if the developer gets leave to rescind, they still have to pay the costs of the defendant, unless there's the defendant purchase has been unreasonably withholding, been unreasonable. So it's a bit like if you apply for a court-ordered easement under Section 88K, then there's an obligation if you get the easement that you still have to pay the cost of the other side, which has a terrible dampening effect in people asking for those or seeking those orders. But in any event, so that's a significant issue. So there's a statutory criteria, which I'll just talk about some cases in a minute. The first point is the cases are all held. Well, this obligation, which remains in all these contracts or sometimes their equivalent terms of 28.1, which is about use reasonable endeavours, still prevails. So to get into the ability to have leave to rescind by the court, the developer still has to satisfy as a precursor issue that it has used its reasonable endeavours to achieve the outcome. So there was some debate about whether this was meant to codify that process and result in these being the only criteria. The court said no, this is a fetter on the ability to rescind. You don't get to having an ability to rescind unless you've complied with the precursor obligations of 28.1. In any event, these cases now have descended into very big bits of litigation. Or potential anyway. They all involve close, and I mean close, comparatively for these sort of issues, analysis of what the cause of the delay was, who's responsible for the delay, in a micro level, the builder, the developer, Counsel, banks, funders sometimes, and the like, whether, as I say, the vendor has complied with the 28.1 obligations, the consequences of the rescission. That is, if rescission is allowed, what's the effect on the purchaser or the vendor? That involves valuation. The value of the land is one of the express criterias. Involves whether the cost or the profit to the developer, whether they're going to make a profit or a loss by reason of not being able to rescind, and general considerations. So I've got a case coming up in a month or so where the developer to vendor is giving evidence. Both parties got valuers about the value of these lots as at the date of the contract, which is everything except, I think, accepting it was the contract price and what it is now. There are town planners who are giving evidence about, well, what was the cause of the delay, who's responsible in a micro level. Each of the defendants, and in this case, but like many other, there are 17 defendants. And each of them, understandably, have put on evidence about their own personal circumstances, about why they've bought these properties, how much they had to borrow, and the like. What the consequences to them will be of the rescission. A rescission, they get their deposit back, obviously, and they're refund of the stamp duty they had to pay, but otherwise they're back at scratch. And so there's evidence about rising costs of construction. This is land. And the like, and so you go through that in some considerable detail, because it is to be recalled, that's a euphemism, just to remind you, each one of these contracts is a separate case. So if you're off the plan developer and you want to rescind, say the big unit block, 20, 30 units, you have to get an order for rescission for each of those lots. Not just, of course you bring the case together, but you are dealing with 30, 27, 17 individual people and their individual circumstances. And some of them, I mean, especially not so much in real property which is completed, but some of these land subdivisions, some of the purchasers are actually sort of smaller scale developers themselves. They want to build properties themselves and make a profit, and they're doing it in the business context, and they're well aware of the issues associated with developments themselves. Some are more, I can just call it, affluent mums and dads. Some are more, struggling mums and single parents, sort of say. And this legislation is meant to, officially it does, gradate those, by reference to these criteria, those considerations. So they are potentially long and expensive bits of litigation, and maybe that's a good thing to promote certainty for the perspective of the purchasers, place the commercial risk on the developer vendors, who after all are better able to shape the product, about the length of the off the plan obligations, the sunset dates, their financing, to make sure they are able to properly document and achieve the outcome. 5 minutes. I'm finding this interesting, I don't know anyone else. So there are 4 cases, and only 4 cases on this legislation so far in New South Wales. There's other legislation, by the way, similar legislation being introduced elsewhere in other states, but no cases. So there are 4 cases. They're in the list in that document I handed around. I'll be very quick about them. So there are 4. 3 of them failed outright. That is, the judge, after looking, 3 judges after looking at them the facts closely, and I was going to give you a bit more of the facts of them, but I'm running out of time, so I apologise. They said no, you've failed to establish the developer vendor failed to establish the criteria, and I don't find it's just and equitable. Some of them are a bit outliers. One case, the first one, was rushed on, there was hardly any evidence, and no one took it seriously, I don't think. It was during vacation, and Justice Black, who in the first case just said no way. And one of the cases is rather unusual features with a particular sale by a vendor to the developer with the buyback of, or the part of the consideration being some of the off the plan units. But generally, it's very hard for the developers to get this. What has happened though is, before I turn to the big hole, there's one case called DFG Property Holdings by a judge called Justice Emmett, who some of you may know. And he said, look, I'm not going to allow this, mainly because the developer is going to make so much money. So what happens usually is the developer acting irrationally and commercially, these properties have gone up, they say, I want to get out of this, I want to get a clean slate, I want to sell again the same property, make more money. And he said, well, look, it's understandable, it's rational, that's partly foreseen in the context of the commercial relationship and the risk allocation in the contract. In that case, as in these earlier cases generally, the legislation was introduced and it was retrospective. So the first 3 of these 4 cases where they failed was the government said, well, you need leave from now on. That is, even if the contract was entered into prior to the introduction of this legislation. And so what Justice Emmett did was, so I'm not going to allow it, but if the developer offers an undertaking, which they did, of course, to in effect split the difference, to provide for a mechanism whereby the purchasers would have to pay a bit more, and they would not have to pay the full current contract value or value of the land, and so it was sort of trying to achieve wisdom of Solomon, split the baby in half, and it worked. And so it gave, in the judge's discretion, an ability to achieve a more just outcome. And that was there were a number of contracts there, and the only thing was because of this cost order issue, the judge then said, I'll do a lump sum cost order, and I'll say, and he did. And the costs are $400,000, maybe $500,000. I'll reduce the price that you, the purchasers, have to pay even under this split the difference contract by the amount of money the developer has to pay you for costs. So he brought it further down. Anyway, it's very sensible, and I can see why it's attractive. Now, can I just describe the whole? The whole is the definition of sunset date, which is, it's for those that might recall, was two things. One is off the plan. Hang on, get it right. Is creation of the lot and the issue of the occupation certificate. Now, they're the only two criteria, and a case came along where a developer, and this is where, for those people acting now for developers or purchasers, need to be aware of this. The developers are now starting to have other sunset date issues, other sunset date trigger matters. So they're putting in things like not the creation of a lot and not the issue of the occupation certificate, but the obtaining of the DA. They're putting in things like obtaining the land, the ownership of the land. So there are other trigger events that they're putting into their contracts that are not the sunset dates. And there's a case called Box Hill, which I'm still involved in, for my sins, where the developer did this, he rescinded them all, and there was an issue about whether the sunset date was caught by the definition, and it was ultimately held it wasn't, so he could just rescind them all, and there's this ongoing issue now about whether or not the 28.1 obligations have prevailed. Anyway, so this has produced Vera's tough on me, but I like to think you're interested. Yeah, I know, but it's only coffee. So in November 2022, it's referred to in that little note, it's easy to find online. The Office of the Registrar General put out a discussion paper called the Off the Plan Contracts for Residential Properties, and it referred to, amongst other things, it was all about off the plans, but it talked about this case, it's called Box Hill, and then said, oh, well, do we need to broaden the definitions of sunset date events, sunset events? And they said, well, look, because of this case, we should think about other trigger events, they're called trigger events, like the vendor becoming the registered owner, the vendor lodging the DA, or the vendor getting the lodging documents, lodging plans for subdivision. And they say, well, put out a position paper, well, what do you think about this? And I've got to love the Law Society sometimes. So on the 14th of December 2022, it's referred to in the little note, and it's easy to find online. They responded. Now, I don't want to think why they responded, but they responded the whole lot. And they said, we do not support the expanding sunset event to capture the three trigger events referred to on page 15 of the paper. Now, these are some of the most unconvincing reasons I've ever heard for this, but anyway. The vendor not becoming registered owner is not appropriate as a sunset event given the variety of means by which the vendor may become the owner. I'm not really sure that's a very compelling answer. The vendor lodging a DA and obtaining development consent is not an appropriate as a sunset event given the different stages of the development process across such contracts, and it is also rare for a vendor to contract to obtain development approval by a certain date. And thirdly, the vendor having lodged the plan for registration is of limited value since at an advanced stage the registration of the plan is most likely imminent, and the fact that the registration is more than relevant is far more relevant to the purchaser. Now, that's just interesting and makes it more topical, but the takeaway from this whole talk, if you don't mind me suggesting, is if you're acting for a developer or particularly a purchaser on off-the-plan sales, you need to be aware of the fact you are, point one. It's not just because it's a contract that looks like the land. You've got to work out it is off the plan. You have to understand these provisions, and as I say, there are a number of disclosure provisions which I haven't spoken about, but the disclosure, the cooling off period, for example, is increased from 5 days to 10 days, but The main one is you have to be aware of whether or not there's a hole in the contractual term about whether or not, particularly the purchaser, has the benefit of this obligation of a developer to seek the leave of the court to rescind. That is are they using some other sunset date event? Thank you very much.